Hey everyone, this one is a quite interesting claim from quite a while ago. However, it covers what we should be covering right now. So let's get on with it. I'd like to start this with it's Linda Venda Van Shaick versus Church of Scientology of California, Church of Scientology of New York, Church of Scientology of Florida, L. Ron Hubbard, Mary Sue Hubbard, United States District Court, Boston Civil Action, number 792-491-6. The summary: the plaintiff is a named party in a $200 million class action filed on behalf of thousands of class members nationwide who have been victimized by a pattern of racketeering activities perpetrated by the corporate defendants. Plaintiff alleges various individual causes of action, to wit: fraud, intentional infliction of emotional distress, breach of contract, violations of Fair Labor Standards Act. She was kidnapped and imprisoned for a period of time. She was forced to divorce her husband. After she left the Scientology, she was pursued and harassed, and her confidential auditing information was disclosed to the newspapers. So that is the summary we have. We did find the case law and the case studies. I'm going to switch over to that right now. It gives a little bit more in depth. Again, this is Van Shaick versus Church of Scientology of California et al. The summary: granting Church's motion to dismiss. So this was after the appellate of personal jurisdiction and venue because conspiracy theory did not provide personal jurisdiction absent connection between defendant and acts within the state, and because venue was improper. So basically it was thrown out on its ear through to technicalities. I don't think they ever went through on the case itself, so it got thrown out before it even got to be heard on technicalities, which is a bummer. This, I feel, could be a good ground work for a new case, a new RICO charge in a new class action. Whether it goes complex or class action, I'm not too sure, but this could be a good ground level case that we can study to do this. So the opinion, Civil Action 79-2491 G, Memorandum of Decision and Orders. It was District Judge Garrity. This case raises a number of questions regarding the jurisdiction of the court, the adequacy of plaintiff's pleadings, and the reach of various federal statutes and constitutional guarantees. The decision we state below follow a period of procedural maneuvering between the parties. Imagine that. We preface our discussion of the substantive issues presented for decision by reciting relevant portions of that history. Here's the procedural history. Seeking relief for herself and on behalf of a class she purports to represent, plaintiff Lavenda Van Shaick, a resident of Massachusetts, brought this action originally against the Church of Scientology, Nevada, Florida, Washington, D.C., and New York, and against numerous other corporate and individual defendants. On December 13th, 1979. Wow. Service was made upon the 5 above-mentioned defendants by delivery of the summons to the Director of Legal Affairs of the Church of Scientology of Boston. The defendant, filed a motion to dismiss on January 16th. They argued either then or later that the court lacked jurisdiction over the defendants, that service had been insufficient, that venue was improper, that the First Amendment barred inquiry into the subject matter of plaintiff's complaint, that the complaint failed to state a claim upon which relief could be granted, and the plaintiff's pleadings were defective, and that various parties were improperly named or joined. Plaintiff filed an amended complaint in May in which she dropped her claims against all defendants except the 5 aforementioned churches and 2 individuals, L. Ron Hubbard and Mary Sue Hubbard. She sought to add an additional party plaintiff, Silvana Garitano, and 3 asserted additional claims against the remaining defendants. The complaint, as first amended, asserted that defendants were liable to Van Shaick and Garitano individually for fraud, intentional infliction of emotional distress, breach of contract, and violation of the Fair Labor Standards Act. In addition, the amended complaint sought to state a class action against defendants for treble damages under the civil remedy provision of the Racketeer Influence Corrupt Organizations, so under RICO. Defendants objected to plaintiff's attempts to add a party plaintiff. The court heard oral arguments September 10, 1980, and received numerous briefs to amend her complaint and the defendant's motion to dismiss. Plaintiff moved for a temporary, on September 4th, 81, this is a whole nother year, for a temporary restraining order and for other injunctive relief to prevent the destruction and dissemination of material allegedly stolen by defendants from the office and trash of the plaintiff's attorney. At the hearing, we ruled that this court had personal jurisdiction over the Church of Scientology of California and issued a protective order from the bench. That order, the essence of which was subsequently written and entered on September 14th of 81, directed defendants' attorneys to produce for the plaintiff attorney's inspection some 800 allegedly stolen documents and directed the Church of Scientology of California not to destroy or disseminate those documents. September 8th, plaintiff moved, this is a little bit further back, so the court told Garitanos that her claims and assertions presented in the First Amendment complaint, we directed Garitano to file a pleading seeking either to participate or withdraw from the proceedings. Garitano subsequently advised the court that she had reached a settlement with the defendants, which after review this court approved. So she bailed. She withdrew from the case, leaving Van Shaick the sole named plaintiff. And then on December 24th, 81, Scientology moved. We reconsider our finding of personal jurisdiction over it, and that we conduct an evidentiary hearing to resolve that question. We see no point in embellishing upon that ruling at this juncture, but may, in later ruling on the motion to reconsider, discuss further the issues regarding personal jurisdiction. Motion to amend the complaint. Kind of reading through. Motion to dismiss. For the purpose of this motion to dismiss, we assume that the following allegations contained in Van Shaick's second amended complaint are true. Beginning on October 71 in Las Vegas, Nevada, Bob Harvey, an agent of the California and Nevada churches, represented to Van Shaick that auditing, the central practice of Scientology, was scientifically guaranteed to have certain beneficial physical, mental, and social consequences for the plaintiff. Similar claims were shown to her in the books and documents written by L. Ron Hubbard, the convicted felon, and disseminated to Nevada by the California Church through the mail. Harvey also represented that auditing is confidential, that Scientology is a law-abiding, religious, scientific organization, and that L. Ron Hubbard is a nuclear physicist with degrees from George Washington University in Princeton. Based upon these representations, plaintiff paid $575 to the Nevada and California churches for books and auditing courses between October and March, and continued to purchase auditing services until '74. During this period, Van Shaick worked for the Nevada and California Church full-time. She left Scientology in '74. During the summer of '75, the plaintiff was contacted in Vegas by her auditor, Pam Bevan, who warned her that unless she returned to the Nevada Church, she would be harassed by the church and its adherents. During the same period, she was locked in a furnitureless room for a period of 2 weeks against her will at the offices of the Nevada Church in Las Vegas and was audited for alleged crimes committed against the church. In response, she paid $3,000 to the church and, pursuant to the order to disconnect from her husband, obtained a divorce. In April '77, the plaintiff went to Clearwater for additional auditing, and from April through May of that year paid $5,000 to the Florida and California churches for new books, auditing. She returned to Nevada in April of '77. Van Shaick remained with the church until '79, when she was declared a suppressive person and fled to Boston in fear of harassment from the church. In Boston, Massachusetts, on about September '79, the Nevada, California, and Boston churches and L. Ron Hubbard, acting in concert, attempted to dissuade plaintiff from pursuing her legal remedies by relaying and eventually disclosing her confidential auditing information to her attorney in Boston, by sending Scientologists from New York and Nevada to threaten her, and by causing the Boston church to harass her. Here's where we're going to talk a little bit about the jurisdiction. This is where we need to pay attention of what we need to do the next time. The plaintiff here claims that this court has personal jurisdiction over the corporate defendants under the conspiracy theory of jurisdiction. The theory, which evolved in a number of cases alleging civil conspiracies, is based upon the notion that the acts of a conspirator in furtherance of a conspiracy may be attributed to the members of the conspiracy for establishing, sounds like L. Ron Hubbard gobbledygook if you ask me, establishing jurisdiction over the person, while the mere presence of a conspirator within the forum state is not sufficient to permit personal jurisdiction over the non-resident co-conspirators. Certain additional connections between the conspiracy and the forum state will support the exercise of jurisdiction. Yeah, I don't know what the hell that just said. These additional connections exist where substantial acts in furtherance of the conspiracy are performed in the forum state, and the co-conspirator knew or should know that the acts would be performed there. So basically, they're saying that the plaintiff should have known that Nevada and New York and Florida and all of them were up to the same acts. And this is a federal court, not state court. So maybe the federal court, well, federal is going to be the RICO. Moreover, those federal courts which have exercised jurisdiction under the conspiracy rationale have done so on the basis of the long-arm statutes applicable in the forum states. What are long-arm statutes? Copy. Let's do a Google search. A long-arm statute is a law that gives a state court the power to exercise personal jurisdiction over a non-resident defendant. Okay. This means that the court can hear a case against the defendant and enter a binding judgment even though the defendant is not physically present in the state. Okay, that explains a little bit more for me. Long-arm statutes allow courts to reach out beyond their borders to exercise jurisdiction over non-residents if they have certain contacts with the state. These contacts can include business, committing certain acts, causing damages within the jurisdiction. However, there are limits to the use of long-arm statutes. The defendant must have had sufficient minimum contact with the state. The court must meet the requirements of due process under the 14th Amendment. The court must consider whether it would be unfair to the defendant to assert jurisdiction. That helps a little bit. What do you think? So as formulation stated above makes clear, wasn't very clear, plaintiff's broad general allegations regarding the conspiratorial nature of the Scientology movement, even if proved, would not warrant the assertion of jurisdiction under the conspiracy theory. The theory gives this court jurisdiction only over claims which arise from acts within the Commonwealth. So therein lies the problem, you guys, is that they didn't have the jurisdiction, but the case was there. So this is something then that we need to look at, get around, God darn it, and figure out how we can make this stick. Case details. Okay, so it's giving citing cases that the decision was based on, and I'm sure Scientology came up with every single one of those. But this is definitely an interesting case that that can be emulated, you guys. So with that, I'm going to close it, and we'll move on to the next one. Thank you.